Hello, this is Marco Calabrese. I'm a lawyer, a family lawyer, and work in Rome. I was asked to release this interview about cross-border matters when dealing with the Italian family law. So, with Susan, with the help of Susan Clements, we decided to call this interview a comparative overview of the Italian financial and procedural rules on separation and divorce, and practical consideration when using alternatives to court in cross-border separation and divorce. It's necessary to explain that this interview will only deal with procedural and financial aspects of cross-border separation and divorce, whenever children's issues are not involved, or in the event that the same are dealt with by a different court proceeding. Therefore, child abduction and child maintenance will remain out of this context. About the financial aspects. Until 1975, the financial regime applicable to married couples by default in Italy was the separation of the couple's estates. Since the year 1975, Family Law Reformation Act introduced the standard regime introduced as a standard regime the co-ownership. Therefore, as a matter of law, a nuptial agreement taking place before the state officer results automatically in a co-ownership, unless otherwise agreed to in writing between the spouses. This very important reform, aimed at protecting the weaker party, that is, in the intentions of the rule makers, the bride, does not consider that prior to marriage, one of the parties, due to the intensity of the desire to marry or otherwise, may be susceptible to the other's demands, even though unreasonable. A considerable number of couples are nowadays opting for separation of assets when marrying. This contract can by no means be questioned, nor can it be challenged before the court in case of divorce, regardless of the duration of the wedlock, nor be considered as affected by one party's exploitation of the susceptibility of the other. As a result, all the estates, legacies, and donations pertaining to one spouse will not be included in the co-ownership unless otherwise specified by the legacy or donation contract, which seldom happens. Thus, in the event of a divorce, if one spouse is more affluent than the other, that spouse may as well be sentenced to pay a high ancillary relief to the other spouse and children. But if the better off party was prudently and carefully advised, the money at stake could not be as relevant as in a common law country. About the contracts and orders in separation and divorce. As an absolute majority of cases, divorce in Italy is the outcome of a 3-year separation period. The law provides as well for other cases of immediate divorce: incestuous relationships, total incapacity of the spouses, change of sex, life imprisonment, etc. But fortunately, these seldom occur. As a matter of fact, the dissolution of marriage comes as a result of two different lawsuits, taking place one after the other, the second, the divorce, being often a mere photocopy of the first, separation, though not as the legal fees are involved, which are doubled, in fact. Unlike what happens in other countries, a married couple needs to seek an order from the president of a local court, the tribunale, to live in a state of separation, regardless of whether they have children, properties, or of the length of their marriage. This application must be filed with the local court, with the forum of the last common domicile of the couple, or where the defendant has established his or her new domicile residence or is living abroad. And as a third option, where the applicant is residing. Separation and divorce in Italy do not necessarily rely on a fault-based proceeding, although the acknowledgement of the fault of one party in the marriage breakdown may still be important in order to establish the amount of ancillary relief. Joint application for a so-called consent separation can be filed with the court of jurisdiction where either of the two spouses is domiciled without the need of a real motive. Generally speaking, approval follows within 2 months, maybe 3 months. No limits are set by the law to protect the weaker party. Therefore, an application by consent can be filed for any reason or even for no reason. A consent order might as well be sought as a result of an unconscionable agreement whereby the consent of the weaker party, although apparently granted, might be affected by exploitation of needs, susceptibility, and undue influence. The court will be ready to overrule a consent order pursuant to the separation agreement only when contrary to the interests of the children. Only a few very recent decisions seem to allow parties to having afterthoughts. In all other cases, the court will grant the order, and the parties must accept the consequences of what they have freely and knowingly agreed to. Contrary to the very short and inexpensive joint application, when the separation or divorce is a result of a contentious proceeding, less than 10% on the total of the cases in 2007, the average length of such a proceeding is that of 2 or 3 years, sometimes more. Let's now talk about orders and agreements about housing, alimony in gross, pension plans, and termination bonus. Children must be supported until they become financially independent. By 10–15% of the annual income per child is generally considered an average support amount. The house goes with the children normally until they become independent. This means that the parent who has the main responsibility for guardianship, as we don't have any longer the custody as it was called, the parent who has the main responsibility will hold the family house until the 22nd to 26th year of age of the children. The age is varying depending on the social class, the studies, the number of children, and so on. Shared custody is the normal court provision, except when there are serious grounds for challenging the request. The family house must be released in favor of the legitimate owner as soon as the children become independent, unless the, let's call this party the custodian of the children, is the owner of or the co-owner of the house. In this case, the house will not be automatically released. But real co-ownership seldom occurs for the reason given above. Finally, the default-based divorce still has some importance in Italian law. The partner, who is not to blame for the family breakdown, is entitled to personal maintenance. This implies not only the alimonies, but to a higher monthly amount for his or her support, normally hers. These ancillary reliefs can be fulfilled by a lump sum, the alimony in gross. When the alimony in gross is paid for, no further financial redress can ever be awarded by the court for any reason whatsoever. The Civil Code provides other regulation regarding the estate succession of divorced couples. And finally, about the de facto families, cohabitation and civil partnerships. As we have mentioned above, de facto couples, as opposed to married couples, receive scarce or no protection at all by the Italian law. Also, the regulation examined above regarding the family home remaining with the children's guardian when married couples are parting applies to cohabitants as well since 2007. Few other regulations, mainly local administrative regulations, grant basic aid to unmarried couples. In general, though, single mothers take advantage from special provisions for schooling, health service, etc. Civil partnerships, PACS as the French call it, or same-sex unions, take advantage, in brackets, from no regulation at all. What are the practical issues to consider when dealing with a divorce proceeding between UK or US and Italy? In the event of two spouses of different nationalities, and in the event of spouses of the same nationality residing abroad, the jurisdiction is normally regulated by the Article 3 of the directive, so-called Brussels 2 bis. The jurisdiction may be attracted to Italy in many cases, so that choosing the correct pitch may only be a question of speed, as it often happens in life. Two main considerations must be put on the ground preliminarily. One, how to win jurisdiction. Two, how to follow an ADR method without running risks. A recent judgment of the Italian Supreme Court in plenary session did establish how, given one, the different cause of action between a separation and a divorce proceeding. 2. Provided that a previous separation proceeding is always needed in Italy. And 3. Having been considered that a 3-year separation period is mandatory when an application for separation of partners is filed in Italy, the mere circumstance of a divorce application simultaneously pending abroad will remain irrelevant. 2 practical advice then. If you are standing for an Italian husband or for the more affluent spouse in general, rush to the court of his last domicile in Italy and apply for separation. But when you're standing in a court for an English or US wife or for the weaker party in general, you'd better apply for an attachment or a seizure without hesitating, because the jurisdiction, due to this peculiarity of Italian law, is often at risk. The Jackson rule in UK and many US states' regulations provide mandatory pre-trial family mediation. This is not the case in Italy. The spouse wanting an ADR attempt to be made in these countries should cautiously seek advice by an expert about the ethical rules to which lawyers are subject in case of breakdown of the negotiations. At any rate, the collaborative practice, a collaborative method, more and more widespread in Italy and elsewhere, will guarantee that when the negotiations fail, the lawyers involved will not assist the parties in court, following a disqualification clause contained in the participation agreement, provided that both lawyers involved are qualified as collaborative lawyers, of course. To complete the picture, the out-of-court arrangements between the spouses will only be valid when approved by a family court, which is another good reason to carefully approach the ADR methods when cross-border family matters are involved. Thank you.